Good afternoon, everybody. I'm Liezel Schultz. I'm an attorney with Goldman Schultz Attorneys, and I want to thank Tafta for giving me the opportunity this afternoon to give you a quick talk about the role of executors and the importance of nominating the correct executor in the event of your estate. So the first thing that I want to explain is the role of an executor. An executor basically steps into your shoes after your death. And the main role of an executor in your estate is to distribute your assets in accordance with the provisions of your will and to ensure that all liabilities of the estate is settled. Those are the main functions of an executor. And generally, you would nominate an executor in terms of your will, and it's more often than not one of the first provisions in the will where you need to decide who you want to nominate as the executor in terms of your will. Now, there's a few factors that you need to consider about the executor and the role of an executor before you nominate somebody specific to be the executor in terms of your estate. Firstly, one of the topics that I want to cover is multiple executors. Some people prefer to or want to consider nominating multiple executors in terms of their estate, or nominate multiple executors in their will. That would mean nominating more than one person as executor in your will. So they will be acting as joint executors. Now, the obvious problem, and it doesn't always cause problems, but the main problem with that can occur is people have different views and opinions, and people might not always work well together or come to the same conclusion and decision. So often there might be disputes amongst these multiple or joint executors that would ultimately lead to a delay in winding up of the estate. So I would caution against nominating more than one person to act as executor in terms of your estate. I would rather suggest that you nominate an alternative executor. So your will would state that you nominate a specific person as executor in terms of your estate, but in the event of that person not being able to take up the position, or that person might have predeceased you, that you then nominate an alternative executor. That is a much better solution to ensuring that there is a person standing as executor after your death. So in terms of the wills that I prepare and that I've been preparing for many years, I always advise my clients to nominate an alternative executor. Now, you don't have to nominate an attorney or a person from the bank or your broker as an executor in terms of your will. Doesn't matter who drafts or prepare your will, you are entitled to nominate whoever you wish to act as executor in terms of your estate. However, if you nominate your surviving spouse or a family member or whoever person as executor, and that person is a lay person, in other words, they don't have a professional qualification or they don't have the necessary expertise to act as a normal executor, the master would probably insist that that person who you have nominated obtain the assistance and services of a professional person to assist them with winding up of the estate. Because the winding up of the estate and the process involved in that is quite an administrative function, and you do need to have a bit of legal knowledge to be able to perform that to the end. So in my experience, and for the last number of years, the Master of the High Court insists on liaising or dealing or communicating with a professional person, even though the executor might be a lay person who might be your surviving spouse or family member. The master will insist on that executor obtaining the services of a professional person who the master will be communicating with. Now, also, I've had questions over the years about the legality or the option to nominate a person as executor who lives overseas or abroad. You are obviously, in terms of our law, entitled, as I've said previously, to nominate any person to act as executor in terms of your estate. And if that person lives abroad, the only administrative extra burden, if you can call it that, would be that the master would, because that person lives overseas, the master would insist on a bond of security. And a bond of security basically is it's a form of an indemnity insurance policy. So that person will have to take out an indemnity insurance policy in South Africa, which needs to be provided to the master of the court to ensure that that person performs their functions properly. And if funds or assets goes missing, then obviously that policy will cover that. A bond of security is quite an expensive insurance to obtain, so it is onerous for the estate to obtain that in the event that the executor lives abroad. So for that reason, it is advisable to appoint an executor in South Africa. And as I've said a few minutes ago, nothing in our law precludes you from nominating a person as executor and who lives overseas and resides overseas, but it is onerous because of the fact that a bond of security will have to be organized or arranged. Okay, then just to move on quickly to what would an executor charge for performing the functions in terms of our law to wind up the estate. In terms of the legislation, an executor can charge 3.5% of the gross asset value of the estate. So whatever the value is of all the assets in the estate, the remuneration payable to the executor would be the equivalent of 3.5% of that asset value. And as I've said, it's the gross asset value. That's before deducting any liabilities. So the more assets the estate has and the more valuable assets the estate has, obviously the more the executor's fees will be. I usually advise my clients that, that they can appoint a family member or a surviving spouse as executor, and that family member can then, after your death, obtain the services of a professional person to assist them with winding up of the estate, and then also agree that professional fee of that professional person up front. Which is actually would place them in a better position than just nominating an attorney outright as the executor or nominating a bank or the broker, because they will just through the board charge the 3.5% plus possibly other administrative charges as well. So nominating a surviving spouse or a family member might put them in a stronger position in that they can then negotiate the fees that the professional person will charge them for actually doing the work of winding up the estate. Okay, so also what I wanted to just touch on is what happens if no executor is appointed. And this will happen in the event that you die without a will, because if you die without a will, there is no document that would state who you want the executor in terms of your estate would be. Now, what would happen to the estate of a person that die without a will, or even where a person have died and they have a will, but there is no nomination of an executor in terms of that will? Generally, the master would then insist on the next of kin nominating an executor. So the next of kin would be your nearest family members, who would have to then come to an agreement about what family member or what professional person they all agree should be acting as the executor, and they all have to sign that document, and that then gets submitted to the master of the court. The problem that often arises when that happens is that the larger the family is, or the larger the group of next of kin is, the more chance there is of arguments and disputes and about who the executor should be. And that ultimately would also lead to a delay in winding up of the estate. So that is the biggest problem with that. And also, when the next of kin have come to an agreement on the executor to be appointed by the master would then also require that person to provide a bond of security, as I've mentioned before, in the event of the executor living abroad. In the event of an executor being appointed by the next of kin, the master would require that person to take out indemnity insurance to ensure that they do their job properly and that there is no losses suffered by the heirs and beneficiaries in terms of the estate, which is quite an expensive exercise. And that brings me really to the most important things that I wanted to talk about about executors. And I want to invite anybody that have got any questions or needs some advice or needs a will drawn up or generally advice regarding estates and executors. You are more than welcome to give me a call. As I've said, I'm Liezel Schultz. My office number at Goldman Schultz is 031-201-2111. And you are welcome to call me on that number at any time if you need some further assistance. Thank you very much again for the opportunity.